Um,
That was what's burning around right now. See, but we still need to know what potatoes. We'll see, they got one on that. We don't need to.
All right, good morning, ladies and gentlemen. My name is Judge Marcus Thorpe. It is November 27th of 2025. It's approximately 9:08 a.m. here this morning. And I am the magistrate court judge that will be presiding over this morning's calendar. I'm one of the associate magistrate judges here in Clayton County. Ladies and gentlemen, if you are having trouble hearing me this morning as we go through the matters this morning, please get my attention and let me know in however you so choose so that I can make sure that you get the information that you will need here this morning. There are several things that we are going to go over both prior to the start of your first appearance hearings this morning, but during. That is extremely important. So please listen carefully as it will help you better understand the nature and purpose of today's hearing. First and foremost, ladies and gentlemen, I am not here to try your case, take a plea, or have any legal discussion with you about the specific facts of your case. The purpose of today's hearing is to inform you of what you've been charged with, advise you of your rights, set bond on those offenses where I may do so, and also to schedule a preliminary hearing and to determine whether or not you require the assistance of an attorney. Now, ladies and gentlemen, each of you has the right to remain silent. So please do not attempt to tell me specifics about your case because, again, remember, we are live here this morning. This is being recorded. And so if you say something that you're not supposed to, you're not only making me a witness, but those around you potential witnesses at any trial that you may have in the future. Now, in addition to the right to remain silent, each of you has the right to a presumption of innocence. You have the right to an indictment by a grand jury for felonies or by accusation for misdemeanors, the right to a speedy and public trial by jury, the right to compel the attendance of witnesses to testify on your behalf. You have the right to see, hear, and question witnesses who are called to testify against you. You have the right to testify on your own behalf or offer evidence in your own defense. You have the right to have an attorney represent you. And if you cannot afford an attorney, one can be appointed to represent you if you qualify. Also, if you are not a citizen, for those of you are that may apply to, some of these charges may adversely affect your immigration status. I tell you that because you might want to speak to an attorney who does immigration after the conclusion of today's hearings to discuss that. Now, as I say, in addition to advising each of you of what you've been charged with, I'm also going to tell you if you have a bond, how much that bond is. Now, of course, a bond is an amount that you would post that would allow you to be released from jail pending the resolution of your case. Now, ladies and gentlemen, there are three ways to make bond. The first way would be to pay what is called a cash bond. If I tell you this late morning, ladies and gentlemen, you were charged with battery, family violence, your bond is $6,000. You have the option to pay that bond in total, the $6,000, to the sheriff's office, and any additional fees that they require. They would then hold that bond until such time as your case is closed, whereupon that money will be returned to you. Now, if you don't have the full amount in bond, you can do what is called a commercial bond. That's where you would contact, or someone you know would contact, a bonding company, and you would be required to pay anywhere from 12 to 15% of the bond amount to the bonding company. The difference is a bonding company keeps that money. You don't get it back. So again, if I tell you your bond is $6,000 and you want to use a bonding company, you'd be responsible for about $750. that it will not be refunded to you. Lastly, if you wanted to bond out, you could use what is called a property bond. A property bond is where either you or someone you know has a piece of property that they own, and they have 3 times your bond amount in equity. So if your bond amount is $6,000, they would have to have at least $18,000 in equity in that home to be able to put it up. And then they would be required to bring the deed to that home or that piece of property down to the sheriff's office, who will hold it until your case is closed and then return it to that individual. Now, in addition to letting you know what you've been charged with, how much your bond is, there are some of you all, ladies and gentlemen, who will have special conditions on your bond. That means I will tell you this morning that you are not to have contact with someone or that you are not to go certain places. If I tell you not to have contact with someone, ladies and gentlemen, please listen to me and abide by that bond condition. That means do not have any contact. Don't email them, don't DM them, don't write a song, don't write a message. No sort of contact at all, no telephone calls. Don't do something as simple as write them a song, because that would be a violation of this order, and it would qualify you for an additional charges that may be felonies, up to 20 years in prison and up to an additional $20,000 fine. If I tell you don't return to a particular place, don't go. If it's somewhere that you used to live before the alleged incident happened, please, I will remind you, get with the sheriff's office. And when you bond out, the sheriff's office will escort you, someone from the department, within 10 days of your release. There are also some of you, ladies and gentlemen, who are on active probation. I have reviewed everyone's criminal history this morning. If I find that you are on probation for certain matters, I will advise you of that this morning and advise you you're not eligible for bond. Now, lastly, for each and every one of you, we're going to also talk about what is called a preliminary hearing. A preliminary hearing is not your trial. It is where you are present, however, the judge is present, and the police officer that arrested you, to determine if there is enough evidence for your case to go to the prosecutor. Now, if they determine that it is not enough evidence, your case can be dismissed at that point. Doesn't mean it won't come back, but you will at least be released at that moment. Now, for those of you all charged with felonies, you automatically get a preliminary hearing, and I will give you the date this morning. If you are charged with a misdemeanor this morning, you have an option to get a preliminary hearing. And so if you are charged with a misdemeanor and I tell you that this morning, you can either tell me, yes, judge, I do want my preliminary hearing, or no, judge, I do not want my preliminary hearing. Now, I don't have any preference one way or the other. I just need you to let me know how you would like to proceed. Now, with that, ladies and gentlemen, we will go ahead and enter the oath, and then we will begin. If you would, everyone, please raise your right hand. Do you swear or affirm that the information that you're about to give to this court, as well as the information you provided on your application for court-appointed counsel, is true and correct? If it is, I need everyone to say I do. All right, ladies and gentlemen, if everyone will please, you can go ahead and put your hands down. All right, Deputy, did you want to start with the ladies or those gentlemen? Those 3 gentlemen.
First 3 first. Ladies, I'll go back in there real quick.
Those gentlemen?
Yes, sir.
I got it first, Curry.
Yeah, Owens.
Which one?
Owens. He the first one.
Let me grab Owens. I think I got his stuff. You can go ahead and bring him up to the mic. All right, Mr. Owens, just give me one moment here. All right, so Mr. Owens, you were charged with 1 count of possession of a deadly weapon by an inmate, sir. I have reviewed the charges as well as your criminal history. I am not going to be able to grant you bond this morning. And so you will have a couple of court dates that I'm going to tell you about. Mr. Owens, please turn around so you can hear me, sir. So you're not getting bond this morning. However, you're going to have 2 court dates coming up. The first court date, sir, will be your preliminary hearing. Your preliminary hearing is going to be on the 29th of December of 2025 regarding this. And then you're going to have a second court date, sir, that's going to also be your bond hearing date. That's where they're gonna reconsider you for bond, and that's gonna be heard on the 2nd of January 2026. Do you understand that, sir? Mr. Owens? I need a verbal, sir.
Yes, sir.
All right. Do you have any questions at all?
No, sir.
Deputy, did Mr. Owens? Oh, I see it here. I've got it. Okay. Thank you, sir. All right. Who do you have next that you want to?
I got Mr. McKinney.
That's the one. I'm waiting on them to get me the paperwork. I didn't see his paperwork.
So, his information says he's a fugitive.
Oh, that's why. Okay, I've got it then. Yep, I've got that. Would be one.
And you can bring that.
You can bring him up
Oh,
because I put all those in the back. Let's see. I've got him right here. All right, so Mr. McKinney, your matter is a little different than the others that we have this morning. As I'm sure you probably already know, you have an outstanding warrant from another state. Specifically, your warrant is from Kansas, Topeka, Kansas. Whether you knew that or not, I'm here to advise you of that. What we are here for this morning, sir, is just to make sure how you would like to proceed on your matter here this morning. As I said, you do not have a outstanding case here in Clayton County. You were picked up on a warrant coming from another state. You have a couple of options, sir. Option one would be you tell me, Judge, I'm going to deal with this warrant when I get back to Kansas. And so I would like for you to start the process whereupon we would what is called extradite, meaning we would take you, have them send you back. So the sheriff's office from Kansas, we will notify them. They have 30 days to come down and get you and take you back to Kansas. So that's option one. You want to deal with it there. Option two, sir, is you tell me, Judge, I want to confirm that they did the correct process in order for me to have to go back. So what that means is if you tell me I want to fight this, we're not fighting the underlying warrants. We're not fighting the elements, whether or not you actually did the case. But there is a hearing that you are entitled to here in Clayton County. We would have it, whereupon you would be with an attorney appointed for you to determine whether or not Kansas did all the procedure correct in order to move forward to take you back to Kansas. Now, if you tell me, Judge, I want that hearing, I will gladly give it to you. However, I do, Mr. McKinney, need to advise you that that hearing can take up to 60 days to happen. And then if it does not happen in those 60 days, the law allows Kansas to get another 30 to be prepared. So you could be sitting here for about 90 days until such time as you actually have that hearing. So again, option one, Judge, go ahead and send me back. They've got 30 days to come get you. If they don't come in that 30 days, we release you. If you want to attack the procedure, we can most definitely do that. Like I said, you'd be sitting here at least up to 60 days and possibly another 30 after that. So with that, Mr. McKinney, how would you like to proceed, sir?
One where, they got 30 days to come get me.
Okay. So there is going to be some paperwork, Mr. McKinney, that the deputies will have you sign. It's going to look like the same exact paper. You're going to sign it like over about 6 times here this morning. But we're going to need you to sign it all 6. They're going to then send it to me, sir, and I will sign as well. And then they will notify the sheriff's deputies in Kansas about coming to pick you up, okay?
Okay, so I have no charges here, right? I'm just waiting on them.
That's it. Yes, sir.
Okay, all right.
Thank you.
Thank you.
Yes, sir. And then what was the other one you wanted to do now, Deputy?
Oh, Kevin.
I'm sorry?
Kevin.
I can't hear you.
Kevin. They say he messed his last name up.
Curfew.
Hold on, just give me a
Sir,
last.
what's your last name?
I refuse.
Give me a last name, Stevens.
I refuse. I refuse.
How do you spell it? How do you spell it?
This not my name. I refuse. It's not my correct
Your
name.
last name.
I refuse.
Sir, what is the name they booked you
I
under?
refuse.
Okay. Well, deputies, he can sit in custody then. He doesn't want to tell us who he is so we can locate him.
You know?
Who else anybody else that you have you want to get done?
That's it for.
Okay. All right. So if you want,
The other three.
yep. And then I can start the females, and then when you're ready for that other three, we can go ahead with them.
Yes, sir.
Well, let me go. Okay, so you go to the, in front of the computer.
Right here, man, right in front of the computer, right here.
All right. Good morning, ma'am. Are you Miss Andrews?
Good morning, no, I'm Chloe O'Connor.
Chloe O'Connor. Give me 1 second. ma'am.
That's why. Yeah, 'cause she got a long gym.
That's right.
All right, so Ms. O'Connor, you are charged with 1 count of aggravated assault as a felony, 1 count of terroristic threat, 1 count of criminal trespass, and 1 count of simple assault. The terroristic threat, ma'am, the criminal trespass, and the terroristic threat is a felony, the criminal trespass and simple assault are misdemeanors. So you're charged with 2 felonies and 2 misdemeanors. Do you understand that, ma'am? Now, I'm gonna go over your bond with you. As it relates to the aggravated assault, ma'am, your bond is $25,000. As to the terroristic threat, your bond is $10,000. As to the trespass, your bond is $3,000, and the simple assault is also $3,000. So your total bond, ma'am, is $41,000. You do have special conditions, and they are to stay away from Sophia Gordon and from the address of 1123 Knotty Pine Place, Knotty Pine Place. Ma'am, I understand that this may have been somewhere that you were living prior to this alleged incident. And so, as I said at the beginning, if this is somewhere that you were living, please do not return there unless you are accompanied by the sheriff's office. Do you understand that, ma'am? Other than that, ma'am, your next court date, because you are charged with a felony, your next court date is going to be, if you do not make bond, December 29th at 8:30 a.m. via Zoom. Again, that'll be December 29th at 8:30 a.m. and that will be via Zoom. Miss O'Connor, were you working before you were arrested?
Yes, sir.
Yeah.
Where were you working, ma'am?
As a virtual medical coding assistant. I work in my school.
And about how much money were you making per month?
I don't know. I was getting paid $15 an hour.
Do you have any children?
I have
Okay.
one, and I'm losing one in my stomach. I'm having a miscarriage right now.
Okay, ma'am. So based on the information that you've given me thus far, ma'am, I am gonna go ahead, I'm gonna appoint you a court-appointed lawyer here this morning. So you will have a lawyer free of charge, ma'am, to assist you on your matter, okay? All right, thank you, ma'am. Good luck to you.
Wait a minute.
Oh,
No, hey.
do you want to put her?
They both in medical.
Okay.
Drink this water.
And what's your name, ma'am? Okay. Ms. Andrews, you are charged with 1 count of trafficking in meth as a felony, 1 count of trafficking of cocaine as a felony, identity fraud as a felony, 2 counts of violation of Georgia Controlled Substances Act, both as felonies for possession of drugs, and a 2nd count of trafficking of cocaine. As it relates to the methamphetamine and the 2 counts of cocaine, all 3 trafficking, I have put you on a no bond status this morning. As it counts to the identity fraud, your bond is $3,000. As it counts to the possession of drugs, both counts, $3,500 apiece, ma'am. So for those cases for which you were entitled to bond, your bond is $10,000. For the other charges, ma'am, as I said, you're on a no bond here this morning. Now, let me ask you this, Ms. Andrews, are you working right now?
No, so I'm not able.
I'm sorry?
I'm disabled. I can't walk.
Okay. Do you get any sort of assistance monthly at all?
No, this is not me for disability.
You said you do not get disability?
Not me for it.
They did not? Okay. So what I'm gonna do then, based on that information, well, let me ask you before I decide. Do you have an attorney? Have you spoken to an attorney or anyone you know spoken to an attorney on your behalf to represent you? Ma'am?
No, sir.
Okay. So based on that, Ms. Andrews, I am gonna go ahead and grant you a court-appointed attorney. So you will have an attorney, ma'am, free of charge that will assist you on your case. So as soon as we are done here, I'm gonna send over the paperwork, Ms. Andrews, to the courthouse. You know, unfortunately, we're on, obviously the holidays right now, and so they won't get to you until probably in about a week's time. But you will have an attorney free of charge to assist you on this case. Do you understand that?
I don't go about getting the bond, sir.
Say that, okay, I was getting ready to get to that point, but we can talk about it now.
Okay.
So I was writing here on your paperwork. In addition to your preliminary hearing that you're gonna get, ma'am, your preliminary hearing is gonna be January 29th. Excuse me, not January, but December 29th at 8:30 a.m. via Zoom. You're gonna get a second court date, and that's where they can reconsider bond for you, Ms. Andrews. That second court date for you is going to be January 2nd at 8:30 a.m., and that's gonna be via Zoom. And so that's where they'll be able to review your history again, review the facts of the case, and determine if you're entitled to bond again, okay? So again, say that again.
Soon as I get a bond, another bond hearing, January 2nd.
It's not gonna be till the second, yes, ma'am. So again, those three charges, trafficking cocaine and the meth, no bond. The other three, your total bond is 10,000. Your next court dates are gonna be December 29th for a preliminary hearing and January 2nd for your bond hearing. All right, any other questions for me, ma'am, before I let you go?
If I can get a lawyer, can I like get a court date, so then January?
That I can't advise you that if you do get a lawyer, you'd have to make that request of the lawyer, okay? All right, good luck to you, man.
Yeah.
Yeah. She's a 4, she's 24. Well, I'm 24. No.
I've got, I think, two more females left before the gentleman.
It's Houston, man. Let's go, man. The judge is already spoken. Come on. Maybe this way. Go ahead. Hands behind your back. Let's go. Get that cup on her.
Are you Miss Houston?
Good morning, Your Honor.
Good morning. So, Miss Houston, you were charged with one count of battery family violence, ma'am. There was an allegation that you had been involved in an assault involving someone else. Now, I want to tell you, ma'am, this morning you're going to be released. I'm telling you that not because other than that this is what happened, this is the law and this is what happened. You know, I reviewed the information that was provided to me. There was some information that the officer was required to provide that he did not. So you're being released because of that. Now, I tell you that also because that doesn't mean necessarily that your case may not come back. The officer may choose to amend and correct what was done incorrectly. And then at that point, they will rearrest you. But as of today, ma'am, you are going to be released later today, okay?
Okay.
All right, good luck to you, Ms. Houston.
All right, thank you, Your Honor.
Mm-hmm.
Wait, my name.
Right.
We're down
Okay.
Are you Ms. Macklin?
Yes, sir.
Ms. Macklin, you were charged with one count of criminal damage in the second degree as a felony, one count of criminal trespass as a misdemeanor, and one count of cruelty to children in the third degree as a misdemeanor. As to the felony criminal damage, your bond amount is $3,000. As to the trespass, your bond amount is $3,000. And as to the cruelty, your bond amount is $2,000 for a total bond of $8,000. Now, ma'am, you do have special conditions, and they are to stay away from the alleged victim, Mr. Stephen Cameron. Do you understand that?
Yes, sir.
Lastly, ma'am, because you are charged with misdemeanors, as I mentioned earlier, you have a right to a preliminary hearing, or you can waive that right to the preliminary hearing. Would you like to have your hearing, Ms. Macklin, or waive your right to that hearing?
I would like to have my hearing.
You would like to have it, okay. So your next court date, ma'am, is going to be December 30th. And it's gonna be at 8:30 a.m. and it's gonna also be via Zoom, like we are this morning. Again, that's December 30th. That's 8:30 a.m. and that's going to be via Zoom. Do you understand that?
Yes, sir.
Do you have any questions about what we've talked about so far?
Can you repeat the total amount of bond again? 8,000, you said?
Yes, ma'am, 8,000.
Okay, thank you.
One last thing, hold on for me. Now, Ms. Macklin, I show here that you do have children, you're working. Is this correct that you were making, you said about $2,000?
Yes, sir.
Okay. So based on that, ma'am, I am gonna go ahead, I'm gonna appoint you a court-appointed lawyer. So you will get a lawyer free of charge to help you on your case here this morning. Do you understand that?
Yes, sir.
All right, do you have any questions then? I know we talked about a lot, so $8,000, you're gonna get for bond. We talked about that. We talked about the court-appointed lawyer, and I told you what your next court date is, okay?
Yes, sir.
All right, ma'am, good luck to you.
Thank you.
Thank you.
Next.
Give me one moment, man.
Morning. Yes, sir.
Are you Miss Turner?
No, he's.
Are you Miss Turner?
No, Smith.
All right.
Oh, Smith, I'm sorry. Miss, I don't think I had yours. Miss Smith, what's your first name?
Jasper.
You said Jasper?
Yes, sir.
Okay, I've got you right here. All right, ma'am. You are charged with one count of possession of a drug-related object, ma'am, as a felony, excuse me, as a misdemeanor. And then one count of possession of drugs, Schedule 1 is a felony, and one count of possession of drugs, Schedule 2, which is also a felony, okay? So 2 counts of felony drugs and then 1 count of misdemeanor. Now, ma'am, I have gone ahead and reviewed the charges here and granted you a bond for the drug-related objects. The bond amount is $1,000. For the first count of drugs is $2,000, and for the second count of drugs is $2,000. And so your total bond here today is $5,000. Do you understand that, ma'am?
Yes, sir, I do.
All right. So that part we're done with. As to your next court date, because you were charged with felonies, ma'am, is going to be the 29th of December of 2025 here at 8:30 a.m. and that's going to be via Zoom. Do you understand that? Now, I have here, ma'am, that you are not working. Is that correct?
Yes, sir, I'm not.
Okay, so I am going to go ahead. I'm going to appoint you a court-appointed lawyer, Ms. Smith, so you will have a lawyer free of charge to assist you on your case. Do you understand that?
Thank you.
All right. Do you have any questions about anything we spoke about this morning, ma'am?
No, sir.
All right, ma'am. Well, then that's all I have for you this morning, ma'am. Good luck to you.
Thank you so much.
Who called me? Somebody call? Next up. Oh, you called me? Yeah. Who called in line?
Are you Ms. Turner?
Yes, sir.
Ms. Turner, you are charged with one count of simple battery family violence, ma'am. Your bond amount is $2,500. You do have special conditions, ma'am, and they are to stay away from the alleged victim, Ramel, Ramale Burgess, Burgess. Do you understand that, ma'am?
Yes, sir.
Now, because you were charged with misdemeanors, ma'am, you have the right to that preliminary hearing I mentioned earlier, or you can waive that right to the hearing. Would you like to have your hearing or waive it?
They said to the right.
Wait a minute.
All right, so I am showing that you are requesting that we waive your hearing this morning. Now, because we are waiving your hearing, when we are done here this morning, the deputies will have a piece of paper for you to sign, okay, Ms. Turner?
Okay.
Based on the information you provided, I also, Ms. Turner, have appointed you a court-appointed lawyer, so you will have a lawyer free of charge to assist you, okay?
Okay.
All right, good luck to you, ma'am.
Thank you.
Thank you. All right, and are you Ms. Williams? Ms. Williams, you were charged here with one count of aggravated assault, ma'am, as a felony. Because you were charged with a felony, ma'am, you got an upcoming court date of December 29th at 8:30 a.m. That's going to be via Zoom. That's going to be your next court date. Your bond, and that's if you don't make bond. Your bond amount is $35,000, and you do have a special condition, and that's to stay away from the alleged victim. And the alleged victim in this matter is a Miss Trinity Fair. Do you understand that, ma'am?
That's me. That's not even her name.
Oh, excuse me. I apologize. Relax.
Oh, I'm just man.
So I meant this, excuse me, I meant Serenity Fair, excuse me. They have it as Serenity Fair, okay?
Yes, sir.
All right, so again, to stay away from Miss Serenity Fair, the bond amount is $35,000. I've granted you a court-appointed lawyer, ma'am, and then your preliminary hearing is gonna be on the 29th of December at 8:30 a.m. Do you understand that?
Yes, sir. Thank you so much.
All right, good luck to you, ma'am.
You start with the mails, Your Honor.
Yes, sir.
She got a few of them all at once.
All right, are you Mr. Andrews?
Yes, sir.
Mr. Andrews, you're charged with one count of misdemeanor simple battery. Your bond amount is $2,500, sir. You do have a special condition to stay away from the alleged victim, Mr. Watkins, Richard Watkins, and also stay away from the Atlanta airport, sir, unless you are traveling or you continue to work there. Now, sir, because you are charged with a misdemeanor, you have a right to that preliminary hearing that we spoke of earlier, or you can waive your right to the hearing. Would you like to have it or waive it, sir?
You kind of explain it.
So again, the preliminary hearing is where you're present, the judge and the officer, to determine if there's enough facts for your case to go to the prosecutor. They can dismiss it if it's not, but it doesn't mean it won't come back later on if the officer decides he wants to bring it back. But they can decide there's not enough evidence and release you. Or you can tell me, Judge, I want to just waive it. Just go ahead and send my case on up to the prosecutor so they can get it done sooner. So that's really up to you.
Waive it.
All right. All right. So, sir, I am showing that you are asking that we waive your hearing this morning. So after we are done this morning, the deputies will have a piece of paper that they're going to have you sign. And then once you sign that paper, sir, you and I will be done this morning. Now, looking at the information that you provided, you do not qualify for a court-appointed lawyer, sir. So you will have to get a lawyer of your own, okay?
Okay.
All right, good luck to you, sir.
That mean I make bond or what's that?
No. So I gave you a bond, but whether you make bond or not, you'll need to hire your own lawyer. So I think I told you your bond was, give me 1 second, I'll give it to you again.
25.
It was $2,500.
Yes, sir.
All right, thank you.
Thank you.
I turn this way. You gotta sign it. Lie down, guys.
And are you Mr. Barnes?
Good morning, sir.
Good morning. So, Mr. Barnes, you were charged with one count of criminal trespass as a misdemeanor, one count of battery as a misdemeanor, and you were charged with one count of cruelty to children in the second degree as a felony. Now, let me tell you, the bond amount in that criminal trespass is $2,500. The bond amount on the battery is $2,500. I have dismissed, sir, the cruelty to children charge. Based on the information that they provided, I do not believe that charge is appropriate. So you're only facing misdemeanors here at the moment. Now, because you are charged with only misdemeanors, sir, you have the right to a preliminary hearing I spoke of earlier, or you can waive that right to your hearing. Would you like to have your hearing or waive it?
So the preliminary hearing is me outside of jail.
No, sir. You would still be in custody. So if you don't make your bond, you'll have that hearing, if you want it, with you, the officer, and the judge to determine if there's enough evidence for your case to go to the prosecutor, or they'll dismiss it. Even if they dismiss it, it can come back. Or you can say, Judge, I don't want the hearing, and then it'll move your case a little faster up to the prosecutor.
I mean, I really want to get my own lawyer when I get out.
So that has nothing to do, I mean, that's completely separate. This is just a hearing for the judge to consider the evidence. So you getting a lawyer, I mean, you may get a lawyer before the hearing even happens.
Okay.
Because this is something completely different from that.
All right. So yeah, I'm go with the hearing.
Okay, so if you don't make your bond, sir, your next court date is gonna be December 30th at 8:30 a.m. via Zoom. Again, that's if you don't make the bond. Your next court date will be December 30th
How
at
much
8:30 a.m. and via Zoom.
how much was my bond again?
The bond was 5,000 total.
So that's 500. If
If you use a
rush.
bonding company, it'll be about 650 if you use a bonding company. Okay, now I have reviewed the court-appointed information you provided, sir.
Yes, sir.
You do not qualify for a court-appointed attorney, so you will have to hire your own, okay?
Yes, sir. Can I spend that money today? Can I bond out today?
That's not up to me, that's up to the sheriff.
Okay.
I think that's not good. That's the line. Come on, stay on. Just make sure to call somebody.
Are you Mr. Bartell?
Yes, sir.
All right, sir, you are charged with one count of interference with custody, sir. That is a misdemeanor. Your bond amount is $5,000, sir. Because you are charged with a misdemeanor, you have the right to a preliminary hearing, sir, or you can waive your right to that hearing. Would you like to have that hearing or waive that hearing?
Waive it.
All right, sir, I am showing you are requesting that we waive your hearing this morning. So once you and I are done, the deputies will have a piece of paper for you to sign. Now, I've reviewed the information that you provided to us this morning. You do not qualify for a court-appointed attorney, sir, so you will have to hire your own. Do you understand that?
Yes.
All right, sir, good luck to you.
Let's go. Next in line. Come on, guys. That way. No, come on, sign. Thank you. Y'all just sign.
Are you Mr. Collins?
You know, there's some.
I have Collins, Crawley, and Curry.
Collins.
Oh, I'm gonna have.
Are you Mr. Collins?
Collins.
What's your first name, sir?
Bobby.
Okay. Mr. Collins, you were charged with one count of driving with a suspended license and one count of driving, speeding. The bond amount on the license charge is $1,500. The speeding, $2,500, sir. So your total bond is $4,000. Do you understand that?
Yes.
I understand here that you are not working right now, so I am going to go ahead and appoint you a court-appointed lawyer. So you will have a lawyer free of charge to assist you. The last question I have for you, sir, because you are charged with a misdemeanor, you have the right to a preliminary hearing I spoke of, or you can waive your right and move your case a little faster to the prosecutor. Would you like to have your hearing or waive it, sir?
I'd like to have a hearing. What's the difference?
All right. So the hearing is where it would be you, the judge, and the police officer to review your case and determine if there's enough facts for your case to go to the prosecutor. So if there's not enough evidence, it'll get dismissed. But if you want your case to move a little faster, you would waive it and then it'll go straight to the prosecutor.
Well, I waive it.
All right, sir. So I am showing you are requesting that we waive your hearing this morning. Now, based on that, the deputies will have a piece of paper for you to sign this morning, okay?
Good. Yes,
All right. Good luck to you, sir. Next up should be Crawley and then Curry.
Curry down up again, Your Honor.
Oh, okay. All right, so I'll hold on Curry. Mr. Crawley, you are charged with one count of possession of a firearm by a convicted felon. That's a felony. Your bond amount is $10,000. Giving false name and address, sir, your bond amount is $1,500. Now, because you are charged with a felony, sir, your next court date, should you not make your bond, is going to be December 29th at 8:30 a.m. and that'll be via Zoom. Again, that'll be December 29th. That'll be 8:30 a.m. and that will be via Zoom. Now, Mr. Crawley, I have also reviewed the information that you provided this morning. You do not qualify for a court-appointed attorney, sir, so you will have to hire your own. Do you understand that?
Yes, sir.
All right, good luck to you, sir.
Can I get the total of my bond again, please?
Yes, sir. It was 11,500.
Okay, thank you.
Thank you. All
All
right, are you Mr. Stanley?
Yes.
All right, so you're charged with one count of burglary as a felony and one count of theft by taking as a felony. The burglary, sir, carries a bond of $50,000. The theft carries a bond of $10,000 for a total bond of $60,000. You do have special conditions, sir, and those are to stay away from the address of 2200 Maynard Jackson Road, which is the mainline aviation, where this was alleged to have happened. Do you understand that, sir?
Yes, sir. Yes, sir.
Now, based on the information you provided, sir, you do not qualify for a court-appointed attorney. And so if you would like a attorney to assist you on your case, Mr. Stanley, you will have to hire your own. Do you understand that?
Yes, sir.
All right, so again, your bond amount, sir, is $60,000 total. Your next court date, should you not make bond, is going to be the 29th of December of 2025. And if and when you do make bond, you are to stay away from that location. Good luck to you, sir.
Yes, sir. Thank you.
Should be Mr. Fisher up next. All right, are you Mr. Fisher?
Good morning.
Good morning. Mr. Fisher, you're charged with 1 count of fleeing and attempting to elude, 2 counts of violation of Georgia Controlled Substances Act, possession of drugs, 1 count of possession of a weapon as a felony, and drug-related objects as a misdemeanor. The bond amount for fleeing is $5,000. The 2 counts of possession, $5,000. The possession of a weapon during the commission of a crime, $10,000. And the drug-related objects, sir, carries a bond of $1,000. So your total bond, sir, is $26,000. Do you understand that, sir?
Yes.
Now, looking at the information you provided, I see here that you are working. How much do you make per month, sir?
I'm actually not working right now, but I got contract through temp agencies as a truck driver.
Okay.
But,
Okay. So based on that, sir, I am going to go ahead and appoint you a court-appointed lawyer. So you will have a lawyer free of charge to assist you on your case. Do you understand that?
Yes. Thank you.
All right, good luck to you, sir. That's all I have for you.
You good,
All right,
man?
thank you.
All right. Next. Stand inside that door right there. Set it on deck.
All right, are you Mr. Gray?
Yes.
All right, so Mr. Gray, you are charged with 1 count of felony criminal damage in the 2nd degree and 1 count of simple battery as a misdemeanor. The bond amount for the simple battery is $5,000. The bond amount for the felony criminal damage, sir, I've looked at your criminal history here, and according to what I have, sir, you're still on probation out of Clayton County from 2018. And as a result of that, sir, you do not qualify for bond at this time. And so what's going to happen is you're going to get 2 court dates because of that. Your next court date, because you don't qualify for bond, is going to be January 2nd as it relates to your bond hearing. And then you're also going to give a first appearance date. That's going to be the 29th of December of 2025. So again, because you're on a no bond, you get a bond hearing on the 2nd of January, but your preliminary hearing date is going to be December 29th. So you got 2 upcoming court dates. Do you understand that?
Yeah.
And according to your information, sir, you're making about $3,000 a month? Is that yes?
Yeah.
Okay, so because of that, sir, you do not qualify for a court-appointed attorney. And so if you would like an attorney to assist you on this case, Mr. Gray, you will have to hire your own. Do you understand that? Mr. Gray?
Yes.
All right, good luck to you, sir.
All right, John, we have housing the 5 up here. We're gonna start with Curry.
All right, I'm ready when you are. Are you Mr. Curry?
Sir.
Oh. All right, so Mr. Curry here, you are charged with 1 count of aggravated assault with a deadly weapon and 1 count of possession of a deadly weapon by an inmate, sir. I reviewed the information provided. You do have a special condition that is to stay away from the alleged victim, Mr. Jaden Owens. Your bond amount, sir, you're on a no bond on those both those charges. So because you're on a no bond, sir, you're going to get 2 court dates from here today. The first court date you're going to have is your preliminary hearing, which is December 29th at 8:30 a.m. and that'll be via Zoom. That's your first court. Your second court date is going to be January 2nd of 2026 at 8:30 a.m. via Zoom. So again, first court date is the 29th of December, second will be January 2nd. And lastly, sir, I have gone ahead and appointed you a court-appointed lawyer, so you will have a lawyer free of charge to assist you on your case. Good luck to you, Mr. Curry.
And next would be Gote.
All right. Mr. Gote, you were charged with one count of aggravated assault by strangulation, sir. You do have a special condition, that is to stay away from the alleged victim, Mr. Jaden Owens, in this matter. Now, because you were charged with a felony, sir, you have 2 court dates coming up. The first is going to be your preliminary hearing. That's going to be on December 29th. That's going to be at 8:30 a.m. via Zoom. Your second court date, sir, is going to be January 2nd of 2026, and that's going to be also at 8:30 a.m. That is also going to be via Zoom. That second court date, as I said, is going to be your bond hearing because your current bond, sir, is a no bond status based on the charges. Do you understand that, Mr. Gote? All right, good luck to you.
Our last one is Mr. Royal.
All right. Give me 1 second, Mr. Roy. I'm just looking for your paperwork.
George might be bad. We pull things off. They should have. Georgia. Whole state. Oh. They want to be damn shit. All right. You know what's up, gang?
So, all right, give me 1 second here. I've got it, Mr. Rose. I'll do it this way. So you don't have to wait.
Yes. Hey, Jess.
Sir. All right, so Mr. Royals, you are charged here with 1 count of sexual battery, sir. Your bond amount is going to be $5,000. You do have a special condition, sir, and that is to stay away from the alleged victim, Miss Nicole Davis. Do you understand that, sir?
Mm-hmm.
Is that a yes?
Yes, sir.
Now, because you are charged with a misdemeanor here, sir, you have the right to a preliminary hearing, or you can waive that right to the hearing, sir. Would you like to have your hearing, or would you like to waive your right to the hearing?
I want to have my hearing.
All right, so since you are requesting that we have your hearing, your next court date, sir, because again, you are charged with a misdemeanor, is going to be December 30th, and that's going to be at 8:30 a.m., and that's going to be via Zoom. Again, that's December 30th, that's 8:30 a.m., and that's via Zoom. Mr. Royal, are you currently working, sir?
I've been locked up for the past time I've been here. I've been here like 50-some months. That's what I'm still trying to figure out. What made me wake up and want to grab somebody's ass, slap somebody's ass. That's what I'm trying to find.
So Mr. Royal, hold on, sir, hold on. Now, whether that is true or not, like I said, you're asking for your hearing. And so at that hearing, they will address that at that point. So I can't address that. That's not why we're here today. But I'm gonna go ahead. I've given you the hearing. Since you say that you've been in custody this entire time, obviously you have not been able to work. So I'm gonna go ahead and appoint you a court-appointed lawyer this morning so that you'll have a lawyer to help you at that hearing, okay?
Yes, sir. I also feel like I hit two. He told me I can talk.
Not about your case.
So remember, listen to what they're advising you the right thing, Mr. Royal. So I'm happy to listen, but you don't want to talk about your case because this is being recorded, sir.
I know I was finna say something. It ain't about that. I feel like I hit 2 million on YouTube. She trying to build Cosby me. That's what I was gonna say, but thank you, sir. I'm done.
All right, sir. So again, they'll address that at the appropriate time. But that's what we've got for you today, okay? Good luck to you, Mr. Royal.
Right now, guys. Go. You right now. They're right.
All right, so are you Mr. McNeil?
Yes, sir.
All right, so Mr. McNeil, you were charged here, sir, with 1 count of simple battery as a misdemeanor and 1 count of criminal trespass. Your bond amount for each of those is $25,000 for a total bond of $5,000. You do have special conditions, sir, and that is to stay away from Janae Johnson and the address of 3386 Mount Zion Road. Do you understand that?
Yes, sir.
Now, sir, because you were charged with a misdemeanor, you have the right to a preliminary hearing, or you can waive your right to that hearing, sir. Would you like to have that hearing or waive it? Mr. McNeil?
Can you repeat it, Judge?
Mr. McNeil, I was asking you, do you want to have your hearing or waive your hearing? Okay. So I am showing that you are requesting that we waive your hearing, sir. And so you and I are done this morning. I'm going to grant you a court-appointed lawyer this morning, sir. And the deputies are going to have a piece of paper for you to sign. Do you have any questions, Mr. McNeil?
No, sir.
All right, good luck to you, sir.
All right. You want to sign?
Are you Mr. O'Neill?
Yes, sir.
Mr. O'Neill, you were charged with 1 count of felony criminal damage to property, 1 count of simple assault as a misdemeanor, sir. You do have, criminal trespass as a misdemeanor. These are 2 misdemeanors. Your bond amount as to the trespass is $2,500. As to the simple assault is $5,000. So your total bond, sir, is $7,500. You do have special conditions, and they are to stay away from Devane Walker and from the address of 2109 Battle Creek Road. Do you understand that?
Yes, sir.
Now, sir, because you are charged with misdemeanors, you do have a right to a preliminary hearing, or you can waive your right to that hearing if you so choose. Would you like to have the hearing, or would you like to waive the hearing?
Can you explain to me what that is?
Yes, sir. So preliminary hearing, what we talked about earlier, is where you are present, the judge is present, and the police officer to determine if there's enough evidence on your case to go forward. Or you can say, Judge, I don't want that hearing. I want to move my case along a little quicker. And if you say that, then we will waive your hearing and your case will go straight to the solicitor, to the prosecutor.
Go ahead and do I'm gonna go with the first one.
Okay. So you would like your hearing. So I'm going to set that hearing date, sir. So if you don't make your bond, your next court date will be December 30th at 8:30 a.m. via Zoom. And again, that's only if you don't make your bond. It'll be December 30th at 8:30 a.m. via Zoom. Good luck to you, Mr. O'Neill. Are you Mr. Peters?
No, we're doing Piers last.
Oh, okay. What's your last name, sir?
Dyson.
One.
Hey. You doing so good.
And Robbins is a fugitive.
Yep, I've got him at the end.
This is Tucker, right? You Tucker, sir?
Cersei, seriously, say Cersei.
Oh, so, sure. Well, sir. Well,
Did Ramirez make bond?
Ramirez,
Yeah, I had a Gregory Ramirez.
that's the one that need to translate. You told me to send him back.
Oh, okay. Yep, you're right. All right. So we continued him. All right. So Mr. Searcy, you are charged with one count of misdemeanor obstruction, sir. Because you are charged with a misdemeanor, you have a right to the preliminary hearing I mentioned earlier, or you can waive your right to that hearing, sir. What would you like to do this morning? Have the hearing or waive it?
You can explain it.
Yeah. So preliminary hearing is where you're present, the judge is present, and the officer is present to determine if there is enough evidence to go forward on your case. So you can either say, Judge, I want my hearing, and they'll determine if there's enough evidence, and they'll either they'll either dismiss your case, or your case will then go to the prosecutor. Or you can say, Judge, I don't want to have that hearing at all, and in which case we send it on directly up to the prosecutor, and it does move a little quicker for resolution.
Can I answer that question like with a lawyer or something?
Yeah, you'll have a lawyer there if you do decide you want the hearing.
Oh, so I deny the question.
Say it one more time.
I said I don't want to answer the question right now.
So, okay, so here's what I'll do then, sir, because I've got to make a decision on that. I'm gonna go ahead and set the hearing for you. If you don't make your bond, sir, your next court date is gonna be December 30th at 8:30 a.m. via Zoom, and I'm gonna give you a lawyer free of charge to help you on that, okay?
Yes,
Do you
sir.
understand?
Yes, sir.
All right, sir, good luck to you.
You did, you can go on.
Are you Mr. Tucker?
Yes, sir.
All right, so Mr. Tucker, you were charged with one count of possession of more than 1 ounce of marijuana as a felony, possession with the intent to distribute marijuana, seatbelt violation, and open container. The possession of marijuana of more than 1 ounce of marijuana, sir, I've gone ahead, we're gonna move forward on that charge, Mr. Tucker. Your bond, based on the information that I've seen here, is going to be denied on that matter. As it relates to the possession with the intent to distribute, sir, I am gonna go ahead and dismiss that charge against you. The seatbelt violation, your bond is $200. And then as to the open container, I am gonna go ahead and dismiss that charge against you. So the only two you have remaining, possession of more than 1 ounce of marijuana, I have denied bond, Mr. Tucker. And then the seatbelt violation is $200. And then the other two have been dismissed. Do you understand?
Yeah, man.
Now, sir, because you are charged with, it's okay. Because you are charged with felonies, you're gonna have 2 court dates coming up. Your first court date is gonna be December 29th, and that's gonna be at 8:30 a.m. And that's gonna be via Zoom. That's gonna be your preliminary hearing date. Your second court date, sir, is gonna be your bond hearing date, since you're under no bond. That's gonna be January 2nd of 2026. And that's gonna be at 8:30 a.m. via Zoom as well. Do you understand that, sir?
Yes, sir. So I have to wait for January.
Yes, sir, for your bond. Yes, sir. I have gone ahead, sir, and granted you a court-appointed attorney based on the information you provided. And so you will have a court-appointed lawyer to help you out. All right?
Thanks a lot.
Good luck to you. All right, Mr. Johannes?
Yes, good morning, sir.
All right, sir, you are charged here with 1 count of interference with a security measure as a misdemeanor, 1 count of disorderly conduct or reckless conduct as a misdemeanor, and 1 count of criminal damage to property as a felony. So now, sir, I have gone ahead, I reviewed the information. I am going to dismiss the felony charge, sir. And so you're only going to have a bond on the misdemeanor. So $2,000 on count 1, $2,000 on count 2 for a total of $4,000. Do you understand that?
I understand, yes.
Okay. Now, are you currently working, sir?
I think I am by now unemployed because I'm supposed to be back home already. I'm here as a visitor on vacation.
Okay. So because of that, sir, I am going to go ahead and appoint you a court-appointed lawyer. So you will have a lawyer free of charge, okay?
Right. Thank you.
Lastly, sir, as to the preliminary hearing I've described earlier, would you like to have your hearing or waive your hearing?
The preliminary hearing would be, if I waive it, the whole process will go by quicker, right?
Yes, sir.
Yes, then I'll waive it.
All right, so I am showing that you are requesting that we waive your hearing this morning. So that means the deputies will have a piece of paper for you to sign, sir, and once you sign, that's all I have for you this morning.
Right here.
All right, are you Mr. Woods?
Yes.
Mr. Woods, you are charged with one count of battery family violence as a misdemeanor, Mr. Woods. Mr. Woods, your bond amount is $3,500. You do have a special condition, sir, and that is to stay away from a Tracy Woods. Do you understand that?
Yes.
Now,
Where would I go when
you also need to stay away from the address where this action alleged to have happened. That's going to be 812 Sugarloaf Way. Do you understand that?
Correct.
So if you, as I said earlier, if you have any items, because you previously lived there, sir.
I do.
Then once you're released on bond, if you make bond, you need to get with the sheriff's office within 10 days of your release, and they will assist you in escorting you to get your items. Do you understand that?
Yes, sir.
Could I buy
today?
If you got it, yes, sir. You can do it as quickly as you like. Now, couple of things. Because you are charged with a misdemeanor, Mr. Woods, hold on, Mr. Woods, let's pay attention. Because you're charged with a misdemeanor, you have the right to a preliminary hearing, sir, or you can waive your right to that hearing. Would you like that? Thank you. All right, so then that means the deputies will have a piece of paper for you to sign here, sir. I've reviewed the information you provided. You do not qualify for a court-appointed attorney, sir. And so that means you will have to hire your own attorney, okay?
Okay.
All right, any questions, Mr. Woods?
I just want to know how I can bond out today.
The sheriffs will help you with that. All right, good luck to you.
They here, I'm still.
No, Robbins is next.
Robbins?
Yeah,
You
Robbins.
Robbins?
You find out. No, wait.
Okay, find out today.
So you find out. Wait, are you waiting?
Hey, deputies, give me 2 seconds here. I'll be right back. I need to do one thing.
Then.
And you can have.
Can I speak? Yes. All right, I noticed a first appearance from an out-of-state situation. I didn't already sign the extradition, yeah, like 2 weeks ago. The time is running out by tomorrow night. I'm trying to see about before the judge, is this going to start my 30-day process again? So what you can do is, you explain that to me, explain that to him. That he can look up and see why you brought that up. This is my place. This is what I said to him. You told me, you can't, I said, we don't, you can't give it back. Whenever you do.
All right, deputies, I'm ready for Mr. Robbins.
All damn talk, because he wasn't. I said, all right, thank you.
All right, sir, are you Mr. Robbins?
Yes, sir.
So, Mr. Robbins, your matter is a little different, as I was explaining to one of the gentlemen earlier. You are what we call a fugitive from justice. What that means is, the only reason that you are in custody is because you have an outstanding warrant for your arrest, not here in Clayton County. You don't have any charges pending here. You have charges pending in New Orleans, okay, in Louisiana. Now, there are a couple options that you have, Mr. Robbins. Option one, you tell me, Judge, I'm going to fight this arrest when I get back to New Orleans. I want you to send me back, okay? If you say that, then what will happen is the deputies will get in contact with New Orleans and they have 30 days to come get you. If they don't come get you in those 30 days, we release you, okay? The option two is you say, Judge, I want to fight, not the warrant, but I want to fight the procedure that the New Orleans police used in order to set that warrant out. If you tell me you want to fight the procedure that they used here in Clayton County, then what will happen is they get up to 60 days. You'll sit here for about 60 days, and then you'll get that hearing to fight the procedure. If for whatever reason, New Orleans is not ready in 60 days, they can hold you for another 30 until that hearing happens. So you may end up sitting here for 90 days total if you say you want the hearing. So it's really up to you at that point then, Mr. Robbins. Do you want to have us send you back immediately, or would you like to stay here and fight the procedure that New Orleans police used to get this warrant out on you?
On the 19th of this month, I signed the extradition paper already, and the paper have a certain date on there. So Friday night to Saturday morning is the 31st date, and I should be released. So I was just trying to see, like, does this process start over? My whole 30 days start over, or does it still continue?
So I can't comment on that, sir, because that would be me giving you legal advice. So, you know, the best that I could tell you is you might want to either yourself or with someone's assistance, look into getting an attorney, and maybe they can assist you. But I can't comment on that.
I was just told that you would be able to answer that question.
I can't, sir. I'm sorry that you were told that information, but I cannot give you legal advice from this
Your Honor,
this
he was saying
position.
that he was already came to court for this case.
You had first appearance for it?
That's what he said. He already had first appearance.
I had 3 first appearances.
So this is not the first. So this isn't the first time that you've been online with somebody and they discussed it with you, Mr. Robbins?
No, this is the 3rd time. But I hadn't already signed the extradition papers when they say
Okay.
I was able to
So then,
find out.
okay, so then let me say this. Let me say this. I'm gonna send your name over to my staff and to the rest of the court and bring that to their attention. Because I'll be honest, if by law you've already signed that paperwork, then yes, sir, you do, you know, when that 31st day comes, then you should be released if they made New Orleans aware and New Orleans hasn't come to pick you up. So what I'm gonna do is I'm gonna bring that to their attention, and we'll see what happens. But, you know, based on what you're saying, then yeah, you are correct. Any other questions I can answer for you?
No, Your Honor.
All right, sir. Well, then that's all I have for you. Good luck to you.
All right, thank you. Thank you. I appreciate it. Thank y'all.
All right, sir. And your name?
Ikanga Pettis.
Say it one more time, sir.
Ikanga Pettis. Ikanga Peters.
Okay. Mr. Peters, I have your information here. Is it Petters or Peters? Which do you prefer?
Peters is okay.
Okay. So, Mr. Peters, you are charged with 1 count of rape. Sir, based on that allegation, I do not. I'm sorry?
I have an attorney, please.
Is he here now?
He was supposed to be here. I don't know.
So if he's not here now, sir, I don't have to, I have to get through these charges so he can help you moving forward. We're not going to get into any legal discussion regardless.
Okay.
We're just going to talk about what you're charged with, okay?
Yes, Your Honor.
So you are charged with 1 count of rape, sir. Because of those charges, I do not have the authority to give you bond this morning. You do have special conditions. They're going to be to stay away from Monique Taylor. Because of these allegations, sir, you're going to have 2 court dates. Your first court date is going to be December 29th at 8:30 a.m. here this year via Zoom, just like we are now. Your second court date is going to be January 2nd of 2026, and that's going to be at 8:30 a.m. And that will also be via Zoom, where they can reconsider your bond at that time. Mr. Peters, are you working right now?
Currently with this, I'm not.
Where were you working before you were arrested?
I work in the hospital.
Okay, and I think you said you have a lawyer, is that correct?
Yes, sir. Yes.
All right, sir. So based on that, I'm going to put here that you do not qualify for a court-appointed attorney since you have one already. If for whatever reason that changes and you can no longer afford an attorney, you know, please let someone know so that they can have you apply for a court-appointed attorney, okay?
Yes, Your Honor.
All right, sir. Do you have any other questions for me?
No, Your Honor.
All right, sir. Then that's all I have for you, sir. Good luck to you.
Thank you, Your Honor.
Thank you.
That's all we have on our end, y'all.
All right. Just making sure. Did we do Mr. Seawold?
That's the one who didn't want to tell you his name.
Oh, that was him. Okay.
Yeah, that was him.
That's your right, sir.
Okay, that was him. All right. I'm gonna go ahead and just fill out his paperwork and take care of it.
Okay, yeah, cause he's in the mental dorm, so yeah.
I kind of gathered that from what I read here. Okay, I'll take care of it. Thank you.
Yes, sir. Have a good one. Happy
You
Thanksgiving.
too. All right. Thank you, sir.